Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, we're going to talk about lack of entry into the United States or denial of entry into the United States. This isn't an aspect of the immigration process I talk about overly frequently because usually at the point we get an issued visa, say for a fiancé, spouse, or one of the employment visas like the E2 or the L1. In most of those cases, once the visa is issued, it's not really so much an issue as far as entering the United States. But that being said, when it comes to entering the United States in a non-immigrant visa, the issue of intending immigration, so intent of immigration becomes an issue. What are we talking about here? Well, in the cases where I've seen someone excluded from the United States, denied entry from the United States under these circumstances, it's usually somebody using a tourist visa, and quite frankly, it's somebody usually using a tourist visa improperly. So what are we talking about? Well, you've got an individual, they're coming to the United States, they've been issued what's called a B1, B2 tourist visa, and they basically have been coming into the United States for 6 months intervals, so they've been admitted with a 6-month stamp, and they turn around, for 3 weeks, leave the U.S., and then return for another 6 months. Do this more than maybe once, and it's pretty likely U.S. Customs and Border Protection is going to want to know exactly what that individual is doing in the United States, why they're taking up so much time in the United States, etc. There's kind of a common misconception with respect to tourist visas that once it's issued, especially based on the fact that it's issued for 10 years, and especially based on the fact that most U.S. Customs and Border Protection officers are going to admit tourist visa applicants, if you will, applicants for entry, they're going to admit them for a 6-month period because, in my opinion, 9 times out of 10, that's just what the date, that's just how the stamps are set. And they've got so many people going through that they're just going to stamp them through for 6 months because that's the maximum allowable per entry in B1, B2 status. If it becomes abundantly clear that one is using a tourist visa to live in the United States, then U.S. Customs and Border Protection officers are going to oftentimes take it upon themselves to review that individual before they're coming in, question them of what they're doing, and in a lot of cases they're going to make a finding that that individual is not admissible to the United States on the ground that that individual is an intending immigrant without proper documentation pursuant to the Immigration and Nationality Act. So what does that mean? It basically means this person's coming in on a tourist visa, but they really want to live in America. They really want to live in the United States. And under those circumstances, they're going to go ahead and deny that person entry. Now, there are circumstances where I've seen this ground of inadmissibility crop up in an expedited removal proceeding, which there's other videos on this channel with respect to expedited removal, what that procedure is. It was created under the old IRA Act, and basically the expedited removal proceeding can result in a 5-year ban from returning to the United States and may require an I-601 and or an I-212 waiver in order to return to the United States in some other visa category. So that being said, the reason I bring this up is that expedited removal, that's serious stuff. That results in oftentimes in a significant bar from re-entry to the United States. In other cases, the Customs and Border Protection officer might say, look, you were just here for 6 months, you're coming back in 3 weeks later for, presumably, we're thinking you're wanting to stay another 6 months, you haven't yet, we're going to give you the chance to go ahead and voluntarily depart and go about your business, without being put through expedited removal. Under those circumstances, it might be fairly, and I shouldn't say easy, but it might be rather more straightforward to assist in getting that person re-admitted to the United States. But if expedited removal proceedings are brought into the equation, it's going to be really problematic getting that individual back in the United States in any quick time frame because of the bars associated just with the act of expeditious removal. So to sum up this video, basically those using tourist visas really need to have the intent of a tourist. They need to plan to be in the United States for a relatively short period of time. Now, look, that's not to say it's not possible to go to the United States for a couple of months. You know, people do take long vacations. But that being said, going to the United States for 6-month intervals, you know, and then leaving for 3 weeks and returning for another 6 months, that looks like the opposite. That looks like you're vacationing abroad and living in the U.S. And under those circumstances, it's pretty likely you're going to see a finding of inadmissibility as an intending immigrant without proper documentation.